Here we go.
Okay, why don't we get started? Good morning, everybody. Thank you for joining us. My name's Tess O'Brien Heinzen. I am an attorney at Rennie, Lewis and Lacey, and I'm here joined with my colleagues. I'll just let you guys introduce yourselves quickly.
Hi, I'm Alana Leffler. I'm in the Milwaukee area office.
And Chad Wade in the Oshkosh office.
So thank you for joining us. Today, our training is going to be on the all-employee training on the 2024 regulations. The regulations, the new 2024 regulations have some particular obligations with regard to all employees in the district. And I'm seeing questions come up already. The regulations say all employees. So anyone that you would consider an employee in your district, you will be required to have those individuals receive training. I think all of us on this webinar would agree that anybody who is working with your students in terms of coaches and advisors, any amount of substantial work with your students, even if they don't technically have an employment contract with you, boy, I am a big proponent of having those individuals receive this training, as they are the ones oftentimes that are in those situations with students and observe things and may be privy to conduct that potentially constitutes sex discrimination or sex-based harassment under the regulations. The regulations say employee. I think we would say, boy, the more that you have trained who work with your students, the better. So we're here to talk about the 2024 Title IX regulations. They have an effective date of August 1st, 2024. The new regulations apply to any conduct that occurs on or after August 1st of this year. The old regulations, which came into place in August of 2020, apply to conduct that took place prior to August 1 of this year. The regulations, as you all probably know, anybody who's been in schools for a while, know that the regulations are what effectuate Title IX, which is a federal civil rights law, a pretty simple civil rights law that states no person in the U.S. Can be discriminated on the basis of sex by any entity that receives federal financial assistance. So all public school districts are subject to Title IX, and essentially you have to be sure that you don't deny benefits, you don't deny participation in, you don't deny the individuals who are participating or trying to participate in your district the benefit of or the participation in your programs or your activities, any of those activities in your district. So Title IX on the basis of sex is the basis for it, and you can keep moving ahead on the slides. The regulations, as I said, are what effectuate Title IX. So Title IX is passed by Congress, and the Department of Education, which is the agency that's been charged with implementing and enforcing Title IX, have developed and created the regulations with respect to Title IX. Most of us knew Title IX as the law that required women to be able to participate in sports initially. That law has been put into place and effectuated by regulations, which now address things like sexual harassment. In 2020, it was the first time those regulations addressed sexual harassment, what it is, and what obligations the districts have with regard to sexual harassment. These new regulations start there and change some of the processes for dealing with sexual harassment, but these regulations go further. And these 2024 regulations are what we are going to be talking about in this webinar, and what your obligations are as employees, and some of those bigger changes that we have seen in these 2024 regulations that you need to be made aware of. The first one, and this is the doozy, right? This is the duty. All employees of a school district have a duty to report sex discrimination. Keep in mind, the 2020 regulations were put in place to address sexual harassment and complaints of sexual harassment. These new 2024 regulations address all sex discrimination, including what's now termed, instead of sexual harassment, it's termed sex-based harassment. But these regulations apply to all sex discrimination. That means sex discrimination in terms of equal opportunity to participate in athletics, with respect to, we don't have a girls softball team, but we have a boys baseball team. We don't have as many practices as boys in basketball, or we have to practice late at night and the girls get the practices right after school. So any type of discrimination claim with regard to that also includes any type of discrimination claim with respect to students and employees who are pregnant or who have pregnancy-related conditions. And it also applies to conduct that constitutes what we're going to be talking about shortly, which is sex-based harassment. Employees in school districts, so go back one slide, employees in school districts have an obligation under Title IX to notify the Title IX coordinator when the employee has information about conduct that reasonably may constitute sex discrimination under Title IX. In order to fulfill your obligations, what do you need to know? The most basic of things of what is sex discrimination and what does it include? And number two, who's your Title IX coordinator? If you are sitting here and watching the video, or you're sitting here live today, make sure you know who your Title IX coordinator or coordinators are and how you would report conduct when you have an obligation to do so. Really the two most important things in order to be able to meet your obligations. When we talk about sex discrimination, what do we talk about? We're talking about, first, different treatment or separation on the basis of sex. So districts cannot treat individuals differently or separate them on the basis of sex in a manner that subjects them to more than de minimis harm. You can't treat a girl in sports different than you treat a boy in sports. You can't treat an employee, a female employee, differently on the basis of sex than you do a male employee. Regulations make that very clear. You can't treat them differently in a manner that subjects them to more than de minimis harm. What is more than de minimis harm? Well, the regulations give a little glimpse into it. And as you probably know, the language that is on the bottom of this slide is what has prompted litigation all over the United States. So, adopting a policy or engaging in a practice that prevents a person from participating in an education program or activity consistent with a person's gender identity subjects a person to more than de minimis harm on the basis of sex. Stated in the regulations, and certainly that is the kind of the focus in terms of the litigation that's going on. I will say this right off the bat, is that we sit as public school districts in the 7th Circuit, and the 7th Circuit is a federal circuit court of appeals. There are circuits all around the United States. Ours is the 7th Circuit. And the law that comes down in the 7th Circuit is the law that governs public school districts in Wisconsin. In the 7th Circuit cases of Whitaker versus Kenosha Unified and AC versus Martinsville, the 7th Circuit made clear in both of those decisions in 2017 and 2023 that if a district enacts and enforces a policy that prohibits a student from using a restroom of the gender with which they identify, and in the Martinsville case, they went as far as saying locker rooms, although there were some stipulated facts in that case, it would be a violation of Title IX. not the regulations, but the law of Title IX. That has been the law in the Seventh Circuit since 2017, regardless of what these regulations, whether the 2020 or the 2024 regulations. You can go on to the next slide. In terms of discrimination on the basis of sex, this is the next part of the regulations that has garnered a lot of attention and has been kind of the originator of the litigation. The regulations make clear that the scope of the regulations that on the basis of sex prohibits discrimination on the basis of sex stereotypes. And that means stereotypes that men should only be attracted to women, or women should wear very feminine clothes, or men should wear only clothes that are masculine. So sex stereotypes, sex characteristics. This is, anybody who watched the Olympics may be familiar with the boxing match with the Algerian boxer where this came up. Discrimination based on variations in anatomy, hormones, chromosomes that differ from expectations generally associated with male and female bodies. On the basis of sex also means sexual orientation, different than gender identity. Sexual orientation is sexual preferences, gay, lesbian, bisexual. Gender identity, non-conforming to the sex that's assigned at birth. That includes transgender, non-binary status. And then pregnancy or related conditions. So pregnancy, childbirth, termination of pregnancy, lactation, so breastfeeding of children, medical conditions related to pregnancy, termination of pregnancy, loss of pregnancy, or planning for pregnancy, such as IVF. So as employees, what you need to know is the scope of these regulations includes all of these various categories. So when we talk about districts cannot discriminate on the basis of sex, they cannot discriminate on stereotypes, on the basis of sex stereotypes, characteristics, sexual orientation, gender identity, or pregnancy-related conditions. So we're going to talk next about the conduct and the types of conduct that you might see to trigger a report in terms of sex-based harassment. And I'm going to turn it over to Alana at this point.
All right, thanks, Tess. So like Tess said, in the 2020 regulations did address what was called sexual harassment. So hopefully some of this should be familiar to those of you who were working in the school districts since 2020. The new regulations do tweak some stuff, not only the terminology, but some of the procedural things we'll go through in a minute. But like Tess said, sex-based harassment or sexual harassment, that is one form of prohibited discrimination on the basis of sex under Title IX. So let's dive into what is sex-based harassment so you all know what to report to your Title IX coordinators. There's three categories of sex-based harassment. One is that classic quid pro quo harassment, where let's say an employee conditions some type of benefit on compliance with a sexual act, or like we've had examples, you'll get a raise or you get this position if you send me nude photos, something like that, where it's quid pro quo. The second category is 4 types of pretty specifically defined sexual violence, I would say, type category. And these are defined in different federal regulations. But sexual assault, dating violence, domestic violence, and stalking, that was also in the 2020 regulations. And sometimes we have had these come up, unfortunately, like if there's sexual assaults between students, let's say, even if it's over the weekend, sometimes there's a connection to the school environment where the school is not only, you know, cooperating and potentially referring to law enforcement if it hasn't been referred, but also addressing it from a Title IX standpoint in the school environment. And then the third category is hostile environment harassment. And that's a new term under these regulations. That's defined as unwelcome sex-based conduct that, based on the totality of the circumstances, it has to be 2 prongs. One is subjectively and objectively offensive and is so severe or pervasive that it limits or denies a person's ability to participate in or benefit from the recipient's education program or activity. So there's a lot of terms within that long definition to break down. Notice that we're looking at the totality of the circumstances. So that's going to be, these are all pretty fact intensive analyses that we do in terms of, does certain conduct create this hostile environment, sex-based harassment, does it meet that definition? And that's not what we're going to focus on today, and what will be the focus of what all employees need to know, because that's going to be something for your Title IX coordinator to be doing the analysis for, in terms of, are we triggering this, you know, complaint process or grievance process? Are we reaching out to alleged victims to talk about supportive measures? If there's an investigation, does it ultimately, do we find a Title IX violation? Does it meet this definition? What you guys really need to know is, when are you thinking about reporting something to your Title IX coordinator? So a couple things to point out from this. So there's subjective and objectively offensive. It has to be objectively offensive to a reasonable person, basically, but also looking at it from the perspective of the, you know, the victim, the one who was subject to the conduct. And then severe or pervasive, that or is important, because under the 2020 regs, it used to be an and. So changing that to an or, you know, I know there were a lot of comments the Department of Ed received and responded to, saying like, does this open the door to even more things will trigger the Title IX process, or potentially be Title IX violations, because we're used to have to meet severe and pervasive. Now it's one or the other. But just keep in mind, with the second prong, there's still some limitations, and we've gotten a lot of, you know, questions as we've done trainings and as we've met with school boards and heard public comment at school board meetings, like, okay, so anything is sexual harassment now. It could be any comment, and that's not true, because look at the definition, and especially the second prong. Not only is it severe or pervasive, but it also, we're looking at what impact it has on the person's ability to participate in the district's education programs or activities, which would include like extracurricular athletics, things like that too. This is a non-exhaustive list of some things that could fall under the sex-based harassment category. And again, I just want to reiterate, it's going to depend on the facts and totality of the circumstances. So not every one of these is automatically sex-based harassment, but these are the types of things we want you to keep in mind when you're, you know, whether something gets formally reported to you, or if it's just something you observe when watching an interaction between students. These are types of things you should keep your eyes, ears out for, and should make you start thinking like Title IX, Title IX, if you're observing them, or if someone reported something like this to you. So things like we listed, I mean, assault, obviously, certain slurs, that's been coming up a lot, and just other, you know, jokes. That's something that's always kind of tricky. We have to dive into, like, what was the joke? What's the relationship between the people? All of things like that. Okay, when we're looking at, is some conduct sex-based harassment, there's some factors to consider. So one, we're looking at, again, the impact on that individual's ability to access the educational program, so the district's programs or activities. We're looking at the type, frequency, and duration of the conduct to look at, is it severe? Was it objectively offensive? How many times did it occur? How long did it occur for? Things like that. Also looking at, what are the age of the parties? You know, the Department of Ed comments or discussion of the public comments in the 2020 regulations and in the 2024 regulations do recognize, like, you know, we have different expectations for how adult employees will work in the workplace. And for some, you know, children or who are still like learning how to interact and maturing, not that that like excuses everything, but that's something we take into account, right? Looking at roles within the district, previous interactions between those people, or between the, you know, person being accused of harassment and others, location and context of the conduct, and other sex-based harassment in the program. So we put together a few scenarios, just to get you guys thinking about, here's the types of things that should kind of, have that little light bulb go off and make you think, this is potentially covered by Title IX. I should really think about contacting my Title IX coordinator. Hopefully, as Tess said, you guys all know who that is. So the first scenario, and whenever we do these, we always get questions about, were you talking about our district? And no, these are hypothetical ones, but I think we've all had situations come up that aren't too far off from these. So one, you have a male coach telling sexually charged jokes around student athletes, comments on what students are wearing, like, oh, those shorts are so short, like, things like that. And then it asks questions about the kids' dating lives. So, hey, do you have a boyfriend? Have you gone all the way yet? Like, we literally have had situations come up like that. In all these situations, I don't think we could tell you if there was a complaint and if there was an investigation, this would be the result. Because remember, we're going through all those factors that we talked about before. Like, how often has this occurred? Is one comment enough? I don't know. If there's a couple comments, if a student comes up to you and says, man, this coach is like making some jokes that are making me uncomfortable, and starts telling you about it, that should be causing you to think, oh, maybe I should report this to my Title IX coordinator. Same student has a student teacher. You can see the scenario, comments on teacher's appearance and clothing. That might not be enough. I mean, it might just be a, hey, love that sweater you're wearing. Or you got a haircut, I like it. But then keep going, asking about the relationship with spouse, calling, texting them on the weekends on personal cell. Again, sometimes I know we all text on the weekends, work-related things, maybe not with a student teacher, but then what else is going on? If I were a little younger, I'd try and date you. Okay, that's starting to get more, crossing the line. So we're taking a look at everything in total. When in doubt, I'd say if you're really on the fence, kind of like mandatory reporting, when in doubt, just report it. Get it to the Title IX coordinator, who's really has much more in-depth training on the Title IX process and whether to trigger that Title IX grievance process. So at least you're just getting it into the right hands and fulfilling your reporting obligations. And then the last category is, I just wanted to point out a reminder that, so in this scenario, employees were out at happy hour after professional development. And the male employee was commenting on a female employee's chest after she had a baby. He was asking her if she was breastfeeding her baby, and then also was using some crude language when talking about it. So again, we'd want to know what was said, how it was, interpreted, was it offensive, all those things. But the main point in this scenario wanted to flag for you guys is this, it's out of school, out of work hours, at happy hour, but we still might have to report it depending on what impact it's had to the, like on the ability to access the district's programs. Is it carrying over into the work environment? Things like that. So same with students. If you hear something about out of school conduct, something over the weekend at a party, usually we're going to get more information, and this would be on the Title IX coordinator too, to gather some more information about what is going on and what impact does it have in the school environment. Okay, so one new thing in the Title IX regulations is, like Tess mentioned, it prohibits pregnancy discrimination and says that would be a form of sex discrimination. Also mentions we cannot treat students, employees, applicants differently based on sex in connection with marital status or parental status. We've gotten questions from school boards about, why did our Title IX policy get so long? And part of it is there's a lot of new stuff in the regulations, and this is one area where there's a lot in the regulations in terms of what a district's obligations are with regard to pregnant students or employees. And I won't go into everything on this slide and the next slide, but you can see there are requirements. We can't discriminate against them. We have to ensure equal access to our programs or activities. We might have to provide reasonable modifications for students, like break time for pumping or nursing lactation, a space to do so. Also, it might, a leave of absence might be required. I mean, there's certain things we need to, go through the process to make sure we're not discriminating against people on the basis of pregnancy or, parental status. Also, a thing to point out, pregnancy or related conditions, I think Tess mentioned this, means more than just someone who is currently pregnant. It could also mean a termination of a pregnancy, lactation, breastfeeding after childbirth, recovery time, things like that. Okay, so here's the district has certain obligations for students and employees where we do have to inform them of the district's obligations to, provide modifications to programs, that we can't discriminate, that we have to, allow space and time to lactate. But I think what you guys really need to know, what I want to focus on is, how do we make sure the district can fulfill that obligation? It's again, getting the right information to the Title IX coordinator, or getting the Title IX coordinator's information to this family. So when the student or another person who has a legal right to act on behalf of the student, so the parent or guardian, informs an employee of a student's pregnancy or related conditions. Again, related conditions could be a termination of a pregnancy or recovery from childbirth, nursing, things like that. The employee, so all of you who are watching this, must promptly provide that person with the Title IX coordinator's contact information, and also inform that person that the Title IX coordinator can coordinate specific actions to prevent sex discrimination and ensure the students equal access to the district's education program or activity. So that's what your obligation is. When we were talking about sex-based harassment, you're reporting it to the Title IX coordinator. With pregnancy, if we learn of a student's pregnancy from the student or the parent, we are providing that person with the Title IX coordinator's contact information and what the Title IX coordinator can do for them. The only exception is if the employee reasonably believes the Title IX coordinator has already been notified. I would just take some reasonable steps to confirm that, either by asking the student and parent, oh, have you discussed this with the Title IX coordinator? Or, if you reach out to the Title IX coordinator and they confirm they're already on it. Okay, so that was all on pregnancy. I'm going to turn it over to Chad now to talk about the grievance procedures.
Thanks, Alana. So I think, spent a lot of time so far just sort of talking about what, the fundamental definitions, the things that to be looking out for. And as Alana and Tess have said, right, your employees are your front line in identifying where there is that reasonable belief that there might be a violation here. And really the responsibility then is to pass that information along up the chain to the Title IX coordinator so that they can then assess and do maybe a more thorough assessment, do some fact gathering, interviewing, discussion with the potential, victim complainant, to decide, how to proceed and how we might address this. But we also want to talk about the grievance procedure, because ultimately our obligation under Title IX, excuse me, is to identify these potential issues, not just when in a reactive manner, but to be proactive in trying to address and prevent them before they happen. But when we have a situation where we've made a report, our obligation as a district is to stop that harassment or stop that discrimination, to prevent that from reoccurring in the future, and then to remedy it, and not just focus on this one incident, but also understanding the impacts of it long term, and how do we need to address it for the victim, both the victim, the complainant, and the respondent or the person who is accused, regardless of whether they're ultimately found to have engaged in some sort of discrimination or harassment. And the grievance procedure is really where that, when we talk about formal complaint, that process of identifying what happened and working through that and preventing it from reoccurring and addressing the effects of it long term. So there are a couple of key definitions that we want to talk about in terms of our grievance procedure, but I also want to point out that each of you, to the extent that you have adopted new regulation or new policy based on the 2024 regulations, or even if your old policy, if you haven't adopted, or if your district is sort of taking a pause, looking at your 2020 regulations, because there's a lot of information regarding the grievance procedures that are going to be unique to each individual district, and especially when it comes to timelines in terms of how fast things happen through the grievance procedure. So again, want to encourage, it's really important that you're looking at your own individual policy, whether that's, again, the 2020 policy or based on the 2020 regulations, or if your district has adopted a new policy, looking at that new policy to understand the steps involved in the grievance procedure. A couple things regarding, again, definitions. Who can serve as a complainant? So a complainant can be the student or an employee or the parents of a student who's been subject to some sort of sex discrimination or sex-based harassment. But it also, with a change under the 2024 regulations, was to provide that people that are no longer part of the program, so a student that has a former student or a student who's dropped out, they can still file complaints and serve as a complainant as long as it's based on conduct that occurred while they were trying or attempting to participate in that educational program. So again, an expansion under the 2024 regulations in terms of who can serve as that complainant. We now include those former students, former employees, and even applicants for positions within the district. When it comes to the complaint is, again, there's no magic words on what constitutes a complaint. A complainant doesn't have to specifically say, I want to file a complaint under our Title IX grievance procedure. As long as their request can be understood as requesting an investigation and a determination about alleged discrimination, then our Title IX coordinator is going to treat that as a complaint. Again, new for the 2024 regulations is that now used to be that the complaints needed to be in writing. Now under the 2024 regulations, they can be oral or in writing. So again, a slight change, but a significant one in the ability and removing what was perhaps a barrier at times for individuals to file a complaint. Again, as I mentioned, our obligation as a school district is to identify when we've had a potential violation, to stop it, to prevent its reoccurrence, and then to address the effects of that. And along those same lines, we're looking at what's the kinds of conduct that might result in a formal complaint, and again, who can file those complaints. And so again, as Alana and Tess talked about, we're looking at sex discrimination. We're also looking at sex-based harassment. When there is a claim of sex-based harassment or sex-based hostile environment harassment, we have that obligation, even as Alana talked about with one of the scenarios, even if that incident or that behavior occurs outside of our educational program, if it's ultimately having an impact on, say, a student's access to their education, then we do have an obligation to address and remedy the effects of that sex-based hostile environment. And so, again, whereas previously we would have been more focused in the school environment and our own within our program and conduct within our programs, it's clear through the 24 regulations that has expanded to include conduct that's outside of our program that has an impact inside the program. It also explicitly includes conduct that happens or occurs outside of the United States. The 2020 regulations explicitly said that it didn't include conduct that would occur outside of the United States. However, the 2024 regulations have changed that to say that it can include that. Want to point out that only the victim of sex-based hostile environment harassment or their parents, in the case of a student, they're able to file a complaint. So when it comes to that sex-based hostile environment harassment, someone can't file a formal complaint on behalf of the victim or the alleged victim in that situation. And so really the regulations again are very clear that this is really up to that individual to make the decision of whether or not to file a formal complaint, and that we're not going to allow someone to file it to say, well, I saw this happening, this hostile environment, harassment happening to someone else, and so I'm bringing a formal complaint. Now, that's having said that, certainly the law does allow and the regulations allow for the Title IX coordinator at times may serve as the complainant in place of a student who is unwilling to come forward. And so again, the Title IX coordinator is the one who really assesses that and decides whether or not this is a situation that requires a complaint to be brought on behalf of the individual, or whether we can address the alleged harassment through informal processes or through supportive measures. That is not true for sex discrimination. General sex discrimination, unequal treatment, those things can be filed on behalf of a person, even if they were not sort of the quote unquote victim of that discrimination. So a broader ability to file for other forms of sex discrimination besides that sex-based hostile environment. In terms of the grievance procedures, again, your Title IX coordinator is really the one responsible for supervising your grievance procedures. But if you as an employee were to raise a concern to the Title IX coordinator that they began the process and then went through the grievance procedures, it's possible that you may participate through interviews. You may be interviewed as part of the investigation to determine and document, what did you observe, what was shared with you from the student. So bringing that information to the Title IX coordinator does not mean that you won't ultimately be involved in the grievance procedure. But as a basic understanding for all staff, I think it's important to understand that when we have a formal complaint, the district and the Title IX coordinator is obligated to treat all complainants and respondents equitably. That means that we don't create a presumption that, well, there's a complaint, so there must have been some sort of misconduct. We don't automatically assume that the victim is telling the truth or that the victim is lying, that we have to treat both sides equitably. That also means when we talk about supportive measures, that we are going to be talking and working with the complainant about supportive measures. How can we assist them in addressing the concerns? How do we ensure their safety at school? But it also means that we're going to be having a similar conversation with the respondent, the accused individual. How do we protect them as well? And how do we address the effects of being now accused of engaging in some of this conduct as well? So again, that equitable treatment in both our investigative processes, but also in our supportive measures as well. Again, the district and your Title IX coordinator, investigators, decision makers have an obligation to protect the privacy of parties and witnesses. That does not mean that we can always ensure that everything that's shared is going to be confidential. And so at times there will be, either because of the information that's being shared, it will be clear to others who is the complainant, for example, or who is the witness. But to the greatest extent possible, we have an obligation to protect the privacy of parties and witnesses, and that we're not, as staff members, we're not engaged in the rumor mill and gossiping about, oh, did you hear about this complaint or what is alleged to have happened at school, or, and so just, again, keeping in mind that obligation as a district-wide in not just focused on the Title IX coordinator and the individuals, although they certainly have that obligation as well. Again, your policy, whether you're still operating under a 2020 older policy, or if your district has adopted a new policy, your grievance procedures is going to include a time frame, a reasonable time frame, I should say, on how do we process grievances, how do we investigate, how much time is taken for decision, when is a decision expected. All of those are going to be set forth in your policies. So again, it's important. Again, the district's obligation is to establish those reasonable time periods or time frames. But as staff, you should be familiar with those timeframes and how long the process may look. You may get questions from a student who reports something to you about, well, I just want this to be done over quickly. Having that information certainly can help you in talking with whether it's students or coworkers, before and during agreements procedures. So just being familiar with that is critical as well. Lastly, the regulations do provide for emergency removal in some circumstances. Again, this is a determination that your Title IX coordinator is tasked with. Again, when we're looking at the safety as sort of a supportive measure, we may take steps to say if we have 2 students involved, rearrange schedules to try to avoid having the students interact with one another and be in the same space. Or maybe we look at change if we have, it's unavoidable, they're going to in the same class and we don't have another section available. We may work on, seating and things like that. But in some cases where there's really extreme or significant allegations, we may take the step of actually removing a student from the program. Again, but it does require that individualized assessment and determination of whether that emergency removal is absolutely necessary. And if it ultimately the Title IX coordinator decides that it is necessary, the person who is being removed has the ability and the option to appeal that if it's offered under your policy. So again, checking your policy to determine what provisions have you included or has your board included in regards to appeal as well. Finally, as you all hopefully are aware, you have an obligation to be trained, or the district has an obligation to train all staff. We talked about that, and Tess specifically talked about that obligation. And so, this training is meant and designed to meet all of the requirements under the Title IX regulations for that training. You have to understand, and staff have to be trained on the obligation to address sex discrimination, understanding the definitions that Tess and Alana have walked through in terms of what constitutes sex discrimination as well as sex-based harassment. And again, there are additional training requirements if in the future you are identified as someone who's going to serve as an investigator or a decision maker. There would be additional trainings that we would want or that you would be obligated to receive in order to serve in those roles as well. So, but this sort of, again, basic training for all staff, and that includes, as was I think put in the chat, it's not just your licensed DPI licensed staff, it's all employees. So it's including your custodial staff, your support service staff as well. Need to have training because they're all potentially going to be in situations where they may observe something that should be reported to the Title IX coordinator, or information provided to a pregnant student or a pregnant coworker about their rights under Title IX. Lastly, before we wrap up here, and we're just about out of time, here's a list of resources that are available from the U.S. Department of Education regarding the new rules. There's a fact sheet and rule summary. That first link is about, I think, 1,200 pages long in terms of the regulations. So if you're having trouble, dozing off at night, you may want to give that a try, see if that works for you. But again, a lot of this, we provide a lot of information here, a lot of definitions and things, but really, again, want to emphasize the importance of going back to your own policies and making sure you have a good handle on how your district has made some of the choices that they have the authority to make even under the new Title IX regulations. I believe that's everything that I have. And so I know
I'm gonna just add one thing, a question that somebody had asked about what happens if all conduct occurs outside of the district? Does that still implicate an employee's responsibility to report? And I think the answer is, if you've got conduct that occurs completely outside the district, outside any district sponsored event or activity where the district has absolutely no authority or ability to control the context or the respondent, the person who engages in the activity, that conduct in and of itself isn't something that an employee has to report under Title IX. When it becomes an obligation is when something that happens outside of school, the effect of that starts to spill over into school. So if something happens on the weekend where you've got an assault and people are talking about it on Monday morning and sending social media at school, or harassing the student who's complaining about it, then you need to address that as an employee. You need to report it as an employee, and the district has to address it. So it's really once it spills over into the school environment. I do want to make one more note before we end. We are recording each of the various webinars that we've put out, and including this one. This one will be available this afternoon. We get a lot of questions that people aren't able to access that, or they didn't get an email with that link to the recording. Please check your spam folders, because a lot of individuals are finding those recordings in the spam folders. So if you're looking for it and you don't have it, check there. And if you don't see it, let us know, and we'll be sure to resend it out to you. So we want to make sure you've got these and meet your obligations. We also will have available a compliance sheets that are on your honor in terms of indicating which of the webinars that you attended and watched and what your position is. Someone asked, how can we document our employees who have been trained? Like you do any of your mandatory training, I would keep a list of all employees who were trained, have them provide their name, or, you know, if you're showing this at a professional development, however you would normally do it, keep a list of their names, the dates they were trained, and I would have somebody, your Title IX coordinator, maintain that list and make sure that it's up to date. If you get new employees, that's kind of added to that list of the mandatory trainings that you provide. Thank you very much for joining us. This has been a pleasure to provide this to our clients. And again, if there are questions that we haven't answered, feel free to contact us, and we can get back to you, or contact your own legal counsel if you've got real detailed questions that you need answers to. So thanks very much and good luck. And I hope all of you watching have a great start to your school year.
Thank you, everyone.